And thank you, ladies and gentlemen of the jury. We have quite a record before us in this case, a video record. And the video record was made by more than one camera. We saw it in color, we saw it with synced up audio. That synced up audio and color was the result of that camera owned by Mr. Gavin Seim. We sought to make a video record of this particular proceeding. However, this case, at its root, begins with, like a case so many years before, a person sitting in a seat that was otherwise prohibited. We heard a lot of testimony where the prosecutor asked the state's witnesses, have you ever seen that before? Have you ever seen that before? Have you ever seen that before? Well, trust me when I say that in Mississippi, for 90 years, they had not seen an African American sit in front of the bus. But one day Rosa Parks did it. And she was arrested for doing it. And so the legacy of civil rights begins. And that's what this case is really about. However, tradition sometimes gets in the way of what takes place when a society attempts to improve itself. Now, sometimes society gets it wrong. We got guys wearing baggy pants and stuff that really, you ask yourself the question, do we have to put up with that in the courtroom? There's other times when you have innovation that is widely accepted as society changes. Now, to give you an example, when both the prosecutor and I went to law school, and we didn't have the cell phone technology we had today. We didn't have the internet technology we had today. Now it's possible for anybody to have a phone. They can simply turn it on, make a video record, and the young people, which excludes me, have the ability to just tap right into the internet, put it on Facebook, or put it up here, or put it there, but they can make a permanent record. And in this case, Mr. Seim, who is a professional videographer, knows how to do live streaming. Well, live streaming, what is live streaming? Live streaming is where you have a digital video record that's being made. It's going directly to the internet so that people can see it. It's like live television used to be. We never had that where I grew up, but it's like live television, where the camera's on and whatever happens, happens. And so now, when you look at this live streaming, you have to compare what we're dealing with here. This courtroom is what's called a quintessential public forum. Now, the jury room is not. The judge's chambers are not. The clerk's office is not. But this area here is what's called a quintessential public forum. And you heard the judge himself when the jury veneer was sitting here, being ready to be impaneled. You're all welcome to stay and view this trial because it's public. In fact, the people of Washington have fought long and hard to make sure that their records are public with the Public Records Act, for instance, because people, as a general rule in this society, want public disclosure. So a public record in a public place is protected by laws governing public places, including the amendments of the Constitution, which give us civil rights. Now, when you talk about live streaming just expands this public forum. Instead of it being just us here watching this, anyone who happens to have access to that particular internet channel can also view what's going on. And equally important, a permanent digital record is created. Now, it's an interesting thing that the state is making a digital record of this today. They have a camera there, and they have a camera there. And as we saw in the video, that camera does in fact capture 100% of the jury. And that record is subject to public records disclosure. I could ask for a copy of this video today and get it from that camera. In addition, during the Tel Chastain trial, the state granted the Wenatchee World the right to come in and make its own video record. And Wenatchee World was not required to ask the state written permission. They simply showed up and said, hey, can we shoot? Verbal, the day of the trial. The defendants put a written request on the table a week before the trial. They were denied. The state could make a record, the Wenatchee World could make the record, but these peons could not make the record. Now, so what takes place from here? Now we have a course of events that initiate everything that takes place in this forum that you saw. Now, it's so critical to us here to have eyes that can see and ears that can hear. We look at what we see on the screen. What does it mean? What does it mean? So the very first event that happens is Nathan Seim is confronted for sitting in that chair over the video stream. And then we hear Marcella Presser say, and we listen to it 4 times, the judge says, remove him. Now her testimony on the stand, she didn't say that. She said somebody else said that. Maybe that wasn't what she said. But we heard her voice on the video 4 times say, the judge says remove him. Now, as I asked her, there is no local rule, there is no Washington Administrative Code, there is no statute, there is no constitutional prohibition, there is nothing that prevents a citizen of the United States from sitting at that table in this quintessential public forum. Arguably, the Fifth Amendment and the Sixth Amendment and the 14th Amendment protect the right of association for a person to be there. Arguably. I'm not going to make that an issue of law, but it does go to an element of the crime as to whether or not there's reasonable doubt. We'll discuss that. So this series of events begins here. And one of the questions you have to ask yourself is, did the judge or the state, and it really makes no difference whether it was the judge, Marcella Pressler, or whether it was independently done by the officers in the room, somebody working as an officer of the state under the color of law physically removed Nathan Seim from that chair in this quintessential public forum and took him out the door. His testimony was they used his head as a battering ram. Now that is the beginning of events. That is the beginning of events. That is what disrupted the judicial proceeding. That is what was disorderly conduct. That was what was contemptuous and insolent to this proceeding. That event. You have eyes, you saw it. You have ears, you heard it. Mr. Nathan Seim was not arrested. He was just removed. He wasn't arrested, he wasn't charged, and Gavin Seim did not know what his fate was after he was taken out that door. Now you say to yourself, well, is that a crime? Well, I don't know. It's really not essential to our discussion today whether or not it's a crime. But suppose that 2 of you jurors were downtown and you saw Rosa Parks get on the bus and the bus driver said, remove her. And 2 guys got up and grabbed her by the armpits and tossed her off the bus. Has a crime been committed? I don't know. But there's doubt whether or not a crime has been committed. There's doubt whether or not a crime has been committed. Mr. Seim took the position that in fact a crime had been committed. And he relied upon the statements of Marcella Pressler, who said the judge said remove him. He relied on that statement to believe that in fact it was the judge who had initiated the use of force by physically removing his brother from the quintessential public forum. And he confronted her. Now, if you were engaged in the crime, and I confronted you on the front steps of your house, your first obligation, you might say to yourself, you know what, get off my property. But your first obligation is to stop the commission of the crime. Now, if you recall, Mr. Seim's words to the judge were not, you need to let me videotape. That wasn't Gavin's words. Gavin's words were, you need to let my brother back in this courtroom. You ordered him out. You need to bring him back. Bring my brother back. And he used contemptuous, disorderly, and insolent words like ma'am and please. There's nothing on this. I've done a lot of criminal cases, and I'll tell you, I've never seen the case where the defendant hadn't used the F-U-C-K at some point in the proceedings. When he got arrested, when he got handcuffed, when he got put in the back of the car, or she got put in the back of the car. Believe me, the F-bomb comes out. You didn't hear this from Mr. Seim. Why didn't you hear this from Mr. Seim? Why was his reaction, even when he was being cuffed, to say, you're twisting my arm, gentlemen? Because he is a man of respect. And at all times, he treated this courtroom with respect, and in fact, treated the law with the highest respect, demanding that the judge follow the law, follow the Constitution, and follow her oath of office. She, on the other hand, believed that the decorum of the courtroom took precedent over all of that. No, you shut up. She didn't say that. You sit down. Don't tell me to stop committing the crime. You behave yourself in front of me. As somebody might do at their house, telling you to get off their property when you ask them to stop beating their wife. So this is what you're seeing in the events. The circumstances that took place here began with the removal of a person from a seat that in the eyes of the court, he had no right to occupy. Very important in this case. And all things proximately followed. So when we look at these jury instructions, we talk about instruction number 4. To convict the defendant of interfering with the administration of justice, the state, let me go to jury instruction number 10. This is probably the most important instruction in the whole packet. Because this is the instruction that we rely upon, all of us. We rely upon this in our daily walk, everything we do. That when you come up against the inherent authority and coercive power of the state, we put a high burden on the state because the state has the right to take your life and to take your liberty and to take your property. You have a right to one thing, due process. That's what you have a right to. And so we have limited the state. We said, you know what? The authority of the state can be exercised only when you prove each element of the crime beyond a reasonable doubt. Each element beyond a reasonable doubt. So number 10 says, the defendant has entered a plea of not guilty. The plea puts in issue every element of each crime charged. I didn't write it, that's what it says here. The state is the plaintiff and has the burden of proving each element beyond a reasonable doubt. Now let's go back and look and see if there's any doubt. And I believe there is. When we look at instruction number 4, jury instruction number 4, to convict the defendant of interfering with the administration of justice, each of the following elements must be proved. That on the 15th day of January, the defendant interfered with, obstructed, or impeding the administration of justice. And I say to you that the facts on the record, the facts in a record created by the state in their cameras and by Mr. Seim in his camera, indicates that the administration of justice was impeded when the arbitrary decision was made to physically remove Nathan Seim from the courtroom. Forget the video. It's not an issue here. What's at issue is Nathan Seim being removed, Gavin Seim demanding his return. That's what's at issue. All of the events proximately caused by his physical removal. So the administration of justice had been terminated by the time Mr. Seim spoke. In fact, Mr. Seim spoke during the commission of an ongoing crime, arguably. And if there is an argument that can be made, and I can make it in front of you in good faith, then there's reasonable doubt as to this charge. Let's look at jury instruction number 6. To convict the defendant of the crime of disorderly conduct, each of the following elements must be proved beyond a reasonable doubt. That on the 15th day of January, the defendant intentionally disrupted a lawful assembly. Well, that begs the question. When does the assembly become unlawful? Now, in my opinion, it becomes unlawful when a crime is being committed inside that facility. It's not a condition of lawfulness, and until the crime is finished, you have an unlawful assembly. Very difficult to disrupt a crime and call that disorderly conduct. So as a result, there is reasonable doubt because the question is twofold. Number one, was there a lawful assembly taking place at the time Mr. Seim made his petition to the court to return his brother? And the answer is no. But there's a second element, that he had no lawful authority to do so. I want you to put yourself on the bus with Rosa Parks for a few minutes. She was arrested, right? Brown versus Board of Education had already taken place. Segregation was no longer the law of the land. Integration was the law of the land. But segregation was still practiced in Mississippi. And she stepped up and said, I'm going to sit at the front of that bus this time. She wasn't big, she wasn't powerful, she wasn't rich. She was right. But she was arrested. Now, you're on that bus. Do you help haul her off? Or do you stand with Rosa Parks? That's the question. And that's the question that Mr. Seim asked. Do you stand with the unlawfulness or do you stand with me? There was never the word revolt used or charge the bench. Stand. Did he have the lawful authority to do that? Do you have the lawful authority to do what's right? What would you do if it was your brother? Let's look at jury instruction number 8. To convict the defendant of the crime of contempt of court, each of the following elements of the crime must be proved beyond a reasonable doubt. That on the 15th day of January, the defendant intentionally engaged in disorderly, contemptuous, or insolent behavior toward a judge while holding court, and that it tended to impair the authority of the court or interrupted the due course of a trial or other judicial proceeding. Again, I submit to you that the trial or other judicial proceeding was interrupted not by the defendant, Mr. Gavin Seim, but had been interrupted already by the illegal removal of Nathan Seim. And remember, not arrested, not charged, no charges of practicing law without a license, no charges of inordinate videoing inside the courtroom, no contempt of court. Contempt of court from a man who continually referred to, even in the middle of this, the judge as ma'am, please, ma'am, bring my son back, my brother back into this courtroom. Please, ma'am, bring my brother back into this courtroom. He's approached by a sheriff wearing the full duty belt, Kevlar, a sheriff, and a sheriff. And he moves from there to here. Not there, here. And they take him from here, and they take him over to that table, they place him in cuffs, and while they're putting him face down on the ground and putting him in cuffs, he says, "You're twisting my arm, gentlemen." It just doesn't sound contemptuous to me. So this is where we are in this case. It's a difficult case. It's a case where Mr. Seim and his brother tried to help out their future brother-in-law at a trial that he couldn't afford an attorney. And they came in to make a video record because why they've learned in the modern world that you protect yourself better with a camera than you do with a gun or pepper spray. And they came in to make a permanent digital record to protect themselves. And this is what happened. And as a result, I'm going to ask you, you're going to look at the evidence again, you're going to see it again, you already have a pretty good memory of what you heard and saw. Let your eyes see what they see. Let your ears hear what they hear. We appeal to your sense of equal rights under the law. No one is above the law, because if one person is above it, then we're all under it. I'm going to ask you to do justice here today. Find that the state has not met its burden to prove the elements of these crimes by a reasonable doubt, and bring a verdict of not guilty on all three charges. Thank you.
Pidgeon, thank you. Mr. Aker, rebuttal?
Thank you. It'll be brief, thanks. The defense has compared himself to Rosa Parks and the judge to a wife beater. The defense is alleging that the judge committed a crime, an unlawful act. Crime of what? Assault, unlawful imprisonment, kidnapping, abuse of office. When what happened was, according to court rule, you have to get permission of the court first before you record. And that hadn't been done. Although they sent in the notice, Mr. Chastain, and remember, it's his trial, not Gavin's trial, not Nathan's trial. It's Mr. Chastain's trial. Mr. Seim hijacks it. What's happening? There's no discussion with the judge. There's no oral or written order yet. And the judge finds out about that. The staff finds out about the live streaming. And remember, what's being live streamed? Right there. The camera was turned to the jury. Live stream. And you could hear the names being called. I defy you to find a court in the United States that allows the photography and videoing of a jury as it happened, to be disseminated as a reality show on the internet. It just doesn't happen. The judge, aware that the rules haven't been followed yet, sends her staff out to do what first? Tell the person, you need to stop recording. Now remember that. That's what Ms. Marcella was talking about. You need to stop recording. The judge will address it. The judge will rule on it. No. 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 You now have a person who's not followed one rule, now is defying the direction of the court. What right does the court have to control the courtroom? That right you're not gonna follow the orders, you're gonna leave. He wouldn't leave. And so, and again, he was invited out first. No. And then, yes, he was forcibly removed. So tell me, which crime has the court committed? In enforcing the rules of the court and her own orders. What crime has she committed? And the answer is none. Now remember what Nathan Seim said before. We anticipated being removed from the courtroom. When? Over the video? Did they forecast that they knew that they were going to get kicked out because of the video? Did they know that they were going to get kicked out because they were advisors? Did they know that they were going to get kicked out because any ruling that they did not like was going to result in this demonstration? That's what that means. Anything that they didn't like, that means the court's committing a crime, in their opinion. Something as simple as a ruling on a rule of evidence, whether something may be hearsay or not. They don't like the ruling. The court's violated her oath of office. She's committing a crime. And by God, I'm Rosa Parks and I'm going to defy this. And that wife beater of a judge. That's hyperbole. That's over the top. This is simply Mr. Seim yelling and screaming at a judge because he's upset. Now, he may have done it politely by using ma'am and gentlemen. But we can talk about our esteemed colleagues, and we call them left-handed compliments. You can insult someone by being nice to them. I'd submit he wasn't being nice. Do we need to arrest you, ma'am? You're in contempt of court. That's not how he said it. It was demeaning, it was degrading, and it was interrupting the process of the court. This isn't about civil rights. This is about due process and respect. He showed no respect, and he interfered with Mr. Shasta's trial.